Welcome. I am John Surushian. I'm the Associate Director for Business and Technology at the Bipartisan Policy Center. Today, we're going to look at the big tech debate and next steps for competition policy. BPC is launching an effort to study and put together recommendations around competition policy by hearing from a diversity of viewpoints. Today, we are planning on focusing on the issues of portability and interoperability. However, given recent activities in Congress, we will also focus on the American Innovation and Choice Online Act, which focuses more on various online practices such as self-preferencing. Before I introduce our expert panel, we have some pre-recorded remarks from our special speaker, former Obama administration White House Chief Technology Officer Anish Chopra, giving his thoughts on the big tech debate and portability and interoperability. With that, let me turn it to Anish.
I want to thank the BPC for hosting today's session, and I greatly appreciate the commitment to bring stakeholders together to look for bipartisan recommendations on what is a really important topic as we enter the 118th Congress. As we've spoken today and will throughout the summer and fall, it's really important that we get our arms around opportunities to bring more competition and innovation in a sector of the economy that's delivered jobs and economic growth and will continue to be an engine of growth for the many years to come. As you remember, a little bit of context and history, we've had a strategy for American innovation that's cut through both political parties. The Obama administration released a version early in 2009. The Trump administration had an office dedicated to it, and President Biden continues to lead. And members on both sides of the aisle have been grappling with ways in which we can make the tech sector work better for everyone. To me, as we think about the framework and my narrow point of view, we've largely agreed on the building blocks of innovation in our economy, whether we invest in human capital, digital infrastructure, thinking about connectivity in the sense of broadband. We have an opportunity to now build on top of that foundation rules of the road that can promote competition and innovation. And it is in the area of interoperability and portability, I would love to spend a few minutes today just to set the stage as we begin a dialogue on what's possible when we come together. As you know, one of the biggest areas of competition is making sure that new entrants have an opportunity to participate. And if the pipes that connect data sets are locked or constrained by incumbents, it makes it difficult for organizations in a digital economy to bring new products and services to market. Making sure that we have a mechanism by which individuals can access their information and share it with whomever they want may be part of a puzzle that allows us to open up markets for competition, especially in this digital age. Secondly, we've thought a lot about what it means to have agency with your data. Many of us are quite familiar and supportive of various tech services, and we've made them our digital homes. We've put data in there, our personal information, maybe our financial or health information, but occasionally we may find the need to switch. And the challenges technically and from a kind of a governance standpoint as to whether or not I can bring all of my data with me if I were to switch to a new service, a big issue, a challenge. We've grappled with these issues in the past. Number portability in the FCC context allowed us to switch phones without giving up that valuable digital real estate in our number. And as we move to a digital economy, more and more of our sensitive assets may have a similar principle. So I think the goal here, if I were to set the stage and a call to action for those of you to participate, is to engage in what we can do to first understand the question, how important are interoperability measures and portability provisions in a digital age. And then assuming we reach consensus on that quite quickly, how might we go about designing recommendations that build on what is core to the American story of promoting innovation and entrepreneurship while ensuring we do protect intellectual property and strengthen the investment case for those who make long-term commitments. I'm confident we can make that balance. I'm even more bullish that we'll have an opportunity to think about where this category of recommendations fit across a larger set of issues. Obviously, a lot of debate about mergers and acquisitions will be part of our dialogue. Obviously, there'll be a conversation about online practices and whether or not there are certain models of anti-competitive behavior that may be harder to detect in traditional definitions of competition policy. But today, we'll stay focused on these issues, hopefully on interoperability and portability. I'll leave you with my final observations. We've seen a number of recommendations that are industry specific. In Dodd-Frank, we had provisions around information sharing in the financial services industry. In the Cures Act, bipartisan legislation in 2016, we had a commitment to the same capability in healthcare. And we've seen many states adopt principles of interoperability and portability in the digital grid or the smart grid. And so we have sector-specific areas where we've made progress, but there may be a chance for us to run wider, if not deeper, in more specific industries to think about cross-cutting themes, especially as we get into broader social services, whether it be in the entertainment space or social media and the like. So with those provisions in mind, I'm excited about being a part of this effort. I wish I could be with you all more directly, and I look forward to the opportunity to engage. Back to you, my friends at BPC.
Thank you, Anish. Appreciate your remarks. Next, I'm going to introduce our expert panel. So let's start with Herbert Hovenkamp. So Herbert Hovenkamp is the James G. Denon University Professor at the University of Pennsylvania Carey Law School. Thank you for joining us, Herbert. Next is Mark Jameson. He is the Director and Gunter Professor of the Public Utility Research Center at the University of Florida's Warrington College of Business. And he is also a non-resident senior fellow at the American Enterprise Institute. Thanks for joining us, Mark. Next is Diana Moss. She is the president of the American Antitrust Institute. Thanks for joining, Diana. And last but not least is Samit Sharma. He is a senior researcher with Consumer Reports. Thank you all for joining us. And before I ask our first question, I want to let the audience know that we want to engage you as well. So you can ask us questions by using the live chat function on YouTube or via Twitter using the hashtag BPC Live. Again, you can ask your questions via the live chat function on YouTube or the Twitter hashtag BPC Live. So please send us any questions you have. With that, I'm going to have my first question for Herbert. Herbert, you've been studying antitrust for decades, and you've written one of the most important textbooks, most used textbooks in this space. I want you to set the stage for anyone in the audience who might not be as familiar with the antitrust debate and how it pertains to big tech. So can you give us sort of an overview of antitrust laws and why people are sort of reviewing and potentially rethinking them in the context of the rise of these digital platforms?
Thank you, and thank you for inviting me. The original federal antitrust law, the Sherman Act, was passed in July of 1890. It focused on two things. One was agreements, which required two or more actors that restrain trade. That was Section 1 of the Sherman Act. And then Section 2 of the Sherman Act applied to single firms, unilateral actions by dominant firms under the term monopolize, which was actually a fairly new term in the law at that particular time. That statute was our only antitrust statute for about 25 years. And then in 1914, Congress supplemented it with the Clayton Act, a progressive era statute that did several things. Number one, it used an effects test, requires the measurement of effects, and then it reached a form of predatory price discrimination in Section 2, tying arrangements in Section 3, mergers in Section 7, and had the first statutory labor immunity in Section 6. Now, just a couple of things about the antitrust laws. They target anti-competitive practices but they are not market specific. That makes them quite different from most forms of regulation today. They don't target any particular market. They're very, very broad in their coverage. We've carved out a few exceptions for some regulated industries, but by default, if it's part of commerce, it's covered by the antitrust laws. There's also no distinction between high tech, low tech, physical products, and so on, for the most part. So the antitrust laws are very, very broad. They're very largely, the specific rules are very largely made by judges. However, that is done with the advice and prosecutorial discretion of the principal antitrust agencies, which are the Justice Department and the Federal Trade Commission. I'll leave it at that.
Thank you, Herbert. Appreciate your very quick overview of the antitrust laws. With that, I'm going to turn it to Diana, and let's get to some specific legislation right now on Capitol Hill. Last week, the American Innovation and Choice Online Act was updated by Senators Amy Klobuchar and Chuck Grassley and posted online. This bill has several key components, including, and I'll list three as I see them, sort of a definition for covered platforms. These are the online platforms the bill applies to. Two, a list of unlawful conduct, so practices that they sort of disallow. And three, affirmative defenses, or what I kind of think of as exceptions to the practices that the bill makes unlawful. So that's kind of how I frame the bills, and we can get more into the specifics. But let's start with the definition of covered platforms as it is in the bill. Can you tell us how the bill defines a covered platform and whether you think the definition they're using and even this approach to picking covered platforms to regulate differently is the right one?
Well, thanks, John, and thanks to the BPC for inviting me here today. It's an honor and a pleasure. Before I get to covered platform, I just want to provide a little bit of context for those who may not be as familiar with the Klobuchar-Grassley bill, which has now been through a few iterations. And it really gets to what Professor Hovenkamp just referenced, which is potential violations of the antitrust law under Section 2. So Section 2 is the monopolization statute, and we worry specifically about, say, vertically integrated companies that own and operate at several levels and have a dominant market share. We worry about those companies having very strong incentives to preference their own products and services, proprietary products and services, at the expense of third parties operating on their systems, right? Whether it be a transmission system or a pipeline, or in this case, an online platform. And so we have these very modern incarnations of vertically integrated firms called digital business ecosystems. And those firms own three things. Typically, they own a platform, which is an engineering concept, which brings together users, buyers and sellers, users and providers, you name it, across search, internet search, social media, fintech, healthcare, just a wide variety of services. But digital business ecosystems also own significant cloud infrastructure to collect and to harvest data, user data. But they also operate in connected markets, applications markets, for example. And so these digital business ecosystems have grown rapidly with essentially no merger control over the last 20 years. We've written about that a lot. And so we find these platforms to be really raising significant market power problems to preference their own products and services at, again, the expense of third parties. And so the bill, it really targets this fundamental problem of discrimination, or what we also call foreclosure. And so a covered platform really, according to the bill, is really any venue which brings together buyers, sellers, users, providers in what we call multi-sided markets. It designates a covered platform based on a number of criteria: number of users, the value of the platform, about a $5.5 billion market cap threshold for that, also designates the digital business ecosystem or the platform owner as what's called a critical trading partner. And so the bill really goes to the heart of the market power concern in preventing different forms of discrimination. And of course, consumers are harmed by this type of discrimination because it prevents them from getting access to competing products and services. It ultimately can raise prices to consumers or result in the misuse and appropriation of their data. So we're talking about things like preferencing the platform's own products and services, offering unequal or unfair terms of service to third-party rivals, frustrating interoperability on the platform, conditioning access to the platform on taking other products and services. These are all sort of classic antitrust concerns. And so the bill really sets forth the notion of the covered platform, a critical trading partner. It sets out what is acceptable or not acceptable types of conduct, meaning legality, but also sets out what are called affirmative defenses, where once the government plaintiff has made a case under this law, should it pass into law, should the bill pass into law, then the burden shifts to the defendants or the parties themselves to really justify their conduct, their anti-competitive conduct. And so the bill covers things like whether an affirmative defense around, say, reasonably tailored conduct or reasonably necessary that could not be achieved through less discriminatory means. And really the heart of that concern is platforms using, say, privacy and data security as a way to justify their otherwise anti-competitive conduct. And so I think that sums it up. We're watching very carefully as this bill moves forward and could very well come to a floor vote here in a couple of weeks, but really goes at the heart of this market power problem raised by these very dominant platforms in the digital sector.
Great, thanks for the overview of the entirety of the bill. Let's dig into this covered platform definition. So you mentioned a number of users, value of platform, being a critical trading partner as sort of some of the issues that they use to determine whether you are a covered platform. I think there was a change made in this draft around sort of payment processors or something along those lines where they were covered previously. Now the language has been changed or taken out. So and this question's for you, Mark. Is this the right approach? So designating covered platforms, and are they using the right criteria, or just any thoughts or suggestions on sort of the criteria they're using and the approach they're using for covered platforms specifically?
Yeah, I disagree with how the legislation is approaching this particular issue. If indeed, as Diana was saying, that we do have a significant market power problem in the tech sectors, the current laws that we have enable us to address that. As Herb was explaining, we've had several decades of work of people figuring out, how do we know exactly what market power is? What's the market? How do you know whether there's power in it? We can analyze that. And if there is, then we do have laws and practices in place on how do you keep someone from using that to damage customers. At the end of the day, the marketplace is really all about the customers. It's not about the competitors. And so our current practices focus on those kinds of things. What this law does, and there are other laws that being proposed that do similar things, is say, well, rather than have us try to go through the difficult thinking about what is a market and how do you know if someone is controlling it and how do we know whether or not it's harming consumers, let's just set some arbitrary metrics. It's going to be X number of customers. It's going to be X numbers of dollars of business or of market capitalization or whatever it might be. And if you exceed those limits, then there must be a problem. But that kind of begs the question, if 1 billion customers, 2 billion customers, 500,000 customers have decided they want to use that particular service, who are we to say that they're wrong in doing that? They've been able to make that choice, and they didn't do it under compulsion. No one grabs me and forces me to use Amazon. No one grabs me and forces me to use Google. I make that choice all the time. So I question a lot of the premises of the legislation. And I don't see that it's actually serving a good purpose, given all the great work that has been done on antitrust and is still going on.
Thanks, Mark. Summit or Herbert, do you want to jump in? Summit, I haven't had.
Yeah,
Herbert, go ahead.
I have a thing or two. Maybe Summit wants to go first because I haven't spoken.
Sure, yeah,
Yeah.
thanks. Actually, Herbert, why don't you take a minute and I'll jump in if that's fine. All right, can you guys hear me okay? So
Yes.
just starting off from where Mark left off, yes, consumers have chosen to use these platforms, and the many billions or millions who've chosen to use this platform. But I think the main issue today is they no longer have a choice to start using something else now. It's difficult for them to switch because there aren't alternatives. And I would argue that we need the legislation and policy proposals like the American Innovation Choice Online Act, because as Dan was mentioning, and many reports have found, there are issues with this sector, which means without pro-competitive intervention of the kind proposed by S2992, the American Innovation Choice Online Act, things won't change. It's been 10 years since these firms have been dominant. And just I have to say about the criteria themselves. I think the criteria in the bill do a very good job of actually capturing the very sort of complex sources of market power which these companies exploit. So, as people have mentioned, the covered platform is an online platform with a large user base. This means it benefits from substantial network effects, right? And this can use this to attract more users and then leverage this across the ecosystem to, as Dan mentioned, many of these companies operate across the digital ecosystem, not just a big online platform, but also cloud services, devices, etc. So they can leverage this market power across the whole digital ecosystem. And then finally, the critical trading partner bit of the bill captures the fact that these companies are effectively running marketplaces that they operate in. They're setting the rules for marketplaces, terms and conditions, which help them further entrench their market power. And what this bill does, I think, is targeted at conduct rules, setting terms and conditions, which would open up competition and encourage more innovation. So I think these are well targeted, and are required also because antitrust law, the existing laws, are useful perhaps to take actions against specific conduct in a piecemeal fashion. But what we are facing here is a more systemic market issue, which needs a policy solution, and that's what the American Innovation Choice Online Act does.
Thanks, Summit. And I'm going to let Herbert jump in. And Herbert, can you also sort of elaborate on existing laws, how they would address issues like when is self-referencing okay, when is it not under existing laws?
Well,
okay, go ahead.
There's very little substantive antitrust law on self-preferencing today. There is some. Exclusive dealing law frequently covers it, but it uses a market share requirement, not an absolute size requirement. I personally think the use of an absolute size requirement as a threshold in this statute is a big and debilitating mistake. And it's both over-inclusive and under-inclusive. First of all, it's over-inclusive because many of the products sold by the large platforms, products and services, actually have fairly small market shares in those services. For example, Amazon is, along with Walmart, one of the two biggest retailers in the United States. It sells roughly 15 to 20% of small kitchen appliances. There's lots of other options, but because we're limiting this bill to online choice, it doesn't cover Walmart. That's also problematic because switching costs are higher, significantly higher for a firm like Walmart than they are for a firm like Amazon. If you look up toasters on Amazon and they send you to the Amazon Basics version and you don't like Amazon's offerings, you can usually escape from Amazon with a mouse click. If you get into Walmart and you see a product display and selection that you don't like, then you got to go back out to the parking lot, jump in your car and drive down. So, it really misses the point. It's under-inclusive to the extent that it doesn't cover many firms, small and large alike, but who have relatively large market shares in the individual products that they seek. And I think that the fundamental error of the bill is that it confuses the size of the platform with the markets for the individual products and services that they sell. And as a result, it makes presumptions about choice that are not proven, and under the statute, they're not required to be proven.
John, could I just jump in here really quickly? I want to just dovetail with what Professor Hovenkamp just said. And that is, the bill absolutely really just looks at the largest of the digital tech platforms. And if the bill does pass into law, and we do see the agencies, the FTC and the DOJ, bringing cases under this expanded authority, it'll be really interesting to see how the courts deal with these cases, how they're litigated, what the outcomes are, how long it takes. For example, courts are not the fastest moving institutions in the world, but importantly, and Herb referenced this earlier, there is a whole cadre of up and coming digital business ecosystems, right? We just did AAI just did an enormous report, which really talks about growth by acquisition in the digital tech sector. That is the model of growth as opposed to organic growth. And so we have this whole set of companies that are hovering under the $5.5 billion market cap threshold. Companies like Salesforce, like Intuit, like Adobe, and others that are valued at maybe $300 billion or $350 billion. Those companies are absolutely the next generation of large digital platforms. So question, how will this bill, should it pass into law, sort of approach that up and coming set of players?
I could add.
Can I just, sorry, not going there.
Good, Mark.
Okay, if I could just add to that as well. So what both Herb and Diana are pointing out is that there are lots of firms stepping into this space all the time. This is a very dynamic market. The idea that customers are now captured just simply isn't true. It's just in the social media space right now. We have TikTok making lots of headlines over how fast it has grown. And the idea that these companies have these network effects that make competition just undoable ignores the fact that there's all kinds of multi-homing, which is customers choosing to be on the US on average about 7 for different social media. And for businesses that use Amazon Marketplace, etc., they typically use about 5 different platforms. So users are finding ways around what some people have considered to be problems. And in fact, this basic idea that someone that has a lot of customers walking through the door, physically or virtually, should not be involved in commerce themselves flies in the face of how commerce has developed greatly over the years. Walmart has its own products. Most grocery stores have their own products. Department stores have their own products. It's true for online platforms as well. Sometimes they treat their products better. Sometimes they treat them less than they do. It depends upon what enables them to grow the basic business. And that is simply a choice that the business makes. And sometimes they do it well. Sometimes they do it poorly. When they do it poorly, the customers go someplace else.
Can I jump in and add?
Yeah, go ahead, Simon. While answering that, I want to also get to our next question, which will be sort of about the bill. In addition to sort of this threshold question, are they taking the right approach with the picking of unlawful practices as defined in the bill and having certain affirmative defense or what I consider to be exceptions to those? Is that also the right approach? Can you touch on that in addition to your response to Mark?
So just a more general response, I think. The bill is targeted at the largest online platforms. And I think it's important to clarify, it doesn't cover all their activities, only the activities where they are clearly dominant. And so we can debate to what extent there's an issue with Google and Facebook in digital advertising, or Apple and Google in mobile operating systems, or Amazon in e-commerce. But I would just point to any number of studies, both here in the US and Europe and by the UKCMA, because we've consistently found that without some sort of intervention, these markets would not become competitive by themselves. In terms of consumer action to move away from these firms, there is the problem is that consumers have a default bias, right? So if Google is set as a search engine, and if Google pays Apple billions of dollars every year to be the default search engine, most people will end up using Google as the default search engine. So it's a combination of network effects, the ecosystem effects, because these firms operate across the digital ecosystem, and consumer inertia and things like default bias, which make it difficult which create barriers to entry and make it difficult for others to come in and compete. On multi-homing, well, it's true. So if you compare Facebook and Twitter, or Facebook and TikTok, people use these other services, but they're not as a substitute. They use them as complements. People still feel the need to be on Facebook or Amazon. And I think that's what the critical trading partner bit of the bill captures. That, of course, Amazon is an e-commerce platform, and there are other ways to get to consumers. But if you're a retail, if you're a seller, if you're a small seller, if you're not on Amazon, then you don't really have a business. And I think I already mentioned, right? I mean, I take Dan's point that there are other companies that are up and coming, and there's nothing in this legislation to stop companies from growing into the thresholds and being covered by the thresholds, and equally from companies from, maybe Amazon or Google decide to voluntarily split up the businesses into different business lines, and then they would not be covered if they didn't meet the threshold. So I don't think it's as static as some other people have said. It is dynamic. It allows companies to come in and out, and in my view, it does capture these the network effects, ecosystem effects, customer inertia, and the ability of these companies to set terms and conditions are captured well by these by the criteria set out in the bill. So, conduct. I'm going to the second part of your question on the conduct restrictions in this bill and whether those are appropriate. So, I think you have to preface that by saying, first, they only apply to giant platforms that are clearly dominant, right, and that have an issue. Second, they only apply if there is a material harm to competition for all conduct. That was explicitly added into the Senate version of the bill. So for the conduct provisions, there are three general conduct provisions for which the FTC or the DOJ would have to prove that there's a material harm to competition before they would apply. And then there are more specific conduct restrictions for which the company can show that there is no material harm to competition, and then it's fine, they won't apply. So do I think those are the right things, the right conduct restrictions to have? Yes, I think they are. So, for example, conditioning access to other services. So this would cover stuff like Amazon Prime, and how sellers who use Amazon's own fulfillment service get a better placement. Now, there's nothing that's built to stop Amazon from offering Prime later. It just has to treat Prime and other services equally. Then there are restrictions on using non-public data to compete with businesses who use the platform. This is, Amazon Basics competing with folks who use Amazon. Amazon is free to use data to improve the marketplace, right? It can't use confidential business data to compete with the very sellers it aims to serve as well. Then there's some restrictions on search results, very reasonable restrictions that simply say, hey, you have to have an objective way to rank folks. You can't just put your own products first. So on and so forth. And there's an interoperability provision, which I think is very useful. And let me just give you an example here, because we talk in theory a lot here. Just one point here. Yeah, sure. So Apple Pay, great innovation, right? Apple entered the payment system, but Apple also stops others from using the Apple payment chip, and that's where it's hindering competition. And this would not stop Apple from offering Apple Pay. It would just mean Apple would have to open up that payment service to others as well. So there's more competition and choice to consumers.
Thanks, Sumit. All right, being mindful of time and wanting to get to portability and interoperability issues, there is one question I do have to ask about this bill, which is the affirmative defenses or certain exceptions made in areas like for preserving privacy and security. Diane, I'll start with you on the exceptions, because you mentioned sort of the reasonably tailored and reasonably necessary language in the bill regarding these exceptions. Can you just quickly tell us about the exceptions they make and whether they strike the right balance with these exceptions? And then I'll let others jump in.
Sure. So I think it's really important to think about this in the frame of how this will all play out in the courts, right? If the bill goes through and the FTC and the DOJ bring cases under this authority, then we're in the courts. And of course, the courts are the ones who make the case law. So we're looking we're trying to sort of game out and troubleshoot what these cases might look like. And so there's two things here, really. And one is a question and the other one is sort of, well, it's another question. So two things. In terms of discriminatory practices, self-preferencing, unfair terms of service, frustrating interoperability, one thing we've learned about the digital business ecosystems is a lot of the self-preferencing conduct goes underground, and it's in the form of algorithmic recommendation systems, right? That's what cloud technology is for, and machine learning and artificial intelligence. And that is going to be very, very difficult for antitrust enforcers to detect that algorithms are inherently biased to self-preference the platform's products and services. So we're really in a situation where the courts are going to have to potentially dig into that if it's covered by the intent of the new law. So there's one sort of open question. The hope would be, yes, that algorithmic preference shaping, which is probably going to be a significant mechanism for self-preferencing, if that's reachable under this law. By the same token, once the plaintiff government has made a case for anti-competitive effects, and there's this burden shift to the defendants to defend their conduct based on these exceptions in the bill, that's going to be another big question for the courts. So think about it. The parties come back and say, okay, well, we had to engage in this conduct that would otherwise be anti-competitive to protect the safety and the privacy of user data. Okay, so now a judge is going to have to render an opinion and evaluate evidence from the defendants on why that is a justification for that conduct. That is also a very open question, and I mention it because the digital business ecosystems, the whole value proposition is to collect and harvest the value of user data. And that often comes with violations of abuse of user data and violations of user privacy. So you now have these platforms offering up these defenses for why their conduct was not illegal, based on the premise that privacy and security, they're protecting privacy and security. Well, these same platforms are the ones who themselves abuse user data and violate user privacy. Plus, we have no privacy law in the United States, so that exacerbates the whole problem. So I think those two issues, algorithmic preference shaping is a way to discriminate, and how judges are going to handle these defenses on the basis of privacy and security, those are going to be really, really big open questions when these cases get to court.
Thanks, Diana. And Mark or Herbert, do you want to sort of respond to the exceptions question, sort of this point Diana made about sort of how the courts interpret the law, if it does pass?
Yeah, on the non-discrimination provision, it reflects, I think, a very fundamental misunderstanding of how resellers who sell multiple products make decisions. They preference all the time. They sell products that sell well, they drop products that sell less well. Most of those are boardroom decisions or managerial decisions. We don't know why Walmart gives front and center display to one particular brand rather than another, but we generally assume we don't have to know because Walmart's operating in a competitive environment and competition will pretty much take care of that problem. I think there is one very critical limitation. It's not a defense at all, but one very critical limitation in the statute, and a lot depends on how courts interpret it. And that is its substantive requirement that preferencing and related conduct must be shown to materially lessen competition. Now that is a little bit of a variation from the Clayton Act terminology, which was substantially lessen competition. Took us about 80 years to figure out exactly what that means. And I think a whole lot rests on that. But if all you're doing is injuring one firm, one particular supplier, for example, is that a material lessening of competition? Well, I would say no, it's not. Not without an inference that competition is injured, which means lower output or higher prices or reduced service in a market. And so the problem with materially lessened competition at this stage is that it can either expand or collapse like an accordion. It could end up meaning a great deal, in which case I don't think the statute would do as much harm, or it could be nothing more than letting tort theory come in through the back door and pursue purely private injuries under the theory that competition is being injured.
Thanks, Herbert. And Mark, do you have any comments on that?
I'll leave it because I know we need to move on.
Okay, that works. Mark, I'm going to ask you the next question, which is about sort of portability interoperability. So the Access Act was recently reintroduced, which is sort of a congressional bill around this idea of portability interoperability. You worked in the telecommunications space in the past, so portability interoperability is probably a huge area for you. Can you tell the audience what exactly we mean by portability interoperability and why it has a connection to sort of competition policy, and even how you think about it?
Sure. When it comes to this issue of portability, the basic idea is that some firm has control of a resource that competitors also need to have access to, a use of, in order to be able to compete. It goes back, and it's very similar to the essential facilities argument from times past. And people make this argument with respect to data, saying things like, well, it's the new oil. And gee, this is just like when we had phone number portability. And we had to have that in order to have competition. But there's some real differences between where we are today with data, for example, and where oil is and was, and what we have with numbers as telephone numbers as well with respect to oil. It's a homogeneous product that everybody used to adapt to different things. Data is by no means homogeneous. And we know that we have lots of firms getting started and competing and growing their own data, not taking somebody else's data. And so you want to pay attention to those kinds of issues when it comes to the issue of data portability, moving data from one place to another, because implicit, or actually explicit in some of the arguments, is that the information that Facebook has about me is my information, that I should be able to take that. But let's just use today's discussion as an illustration. Lots of people are watching this discussion. Are the things they learned about Herb, is that Herb's information and he can take it from them? Or is it theirs because they've gone to the work of observing and Herb says, yes, you can watch me operate. That's how we've tended to think about knowledge and information for centuries of time. And some of the debates over data portability kind of turn that on its head. Let me go to interoperability. Interoperability is something we did in the telecommunications industry because, and this relates to number portability as well, because we had a government-sanctioned monopoly for a very long period of time. And that monopoly served about 96% of the country. It was a monopoly made up of several different companies, but they were all under the government's protection. So in order to try and have competition into that market, the idea was that there are things that company or the cluster of companies control that we have to make them give up. And that's what number portability was about. It was indeed important. And that's what interoperability was too, which was just simply to say that if I set up a telephone company to try and compete with AT&T or to try and compete with what's now Verizon, I needed to be able to interconnect with them. And not only did I need to interconnect with them, in order to, since they had phone lines everywhere, I needed to get access to their facilities. And that's what interoperability was really about. Is that we had a 96%, 98% of the countries covered by this network. And if by this system, and if you can't use that system, there's no way in the world to compete. And so that's what the interoperability came in and addressed. That's not the situation we're in today with big tech. People don't want to use pieces of Facebook. They don't want to use pieces of Amazon. They don't want to use pieces of TikTok. We want them, and they want to build competing platforms. And if we do something called interoperability, what we effectively do is, one, harm the security, because interoperability is really, really hard to do well. We endanger the security of these different types of platforms. And we also, we bias the market towards people who are going to look a lot like Facebook or look a lot like TikTok or look a lot like Amazon, because they're using their network and their systems rather than building their own. We'd actually like for people to build alternative platforms and replace these companies, or replace their platforms anyway. If one of the companies replaces its own, I'm fine with that as well. That's the type of competition we want. We want competition between systems, not just competition for components of the systems.
Thanks, Mark. And I'm going to turn to Herbert. I know you've written a paper about interoperability that I think was published a couple months ago. But before I ask you my specific question, I want to remind the audience, please send any questions you have via the YouTube chat function or via Twitter using the hashtag BPC Live. Again, we're taking questions and trying to incorporate throughout this conversation, so please send any. But back to you, Herbert. Yeah, so you have a paper on this issue of interoperability. Can you give us sort of your take on interoperability? I think you make a distinction between voluntary, court-mandated, and congressionally mandated interoperability. And I think you also talk about interoperability regimes or standards depending on different use cases. Can you talk about those and maybe the paper more broadly?
Sure.
And let me know if I characterize everything correctly.
Interoperability is a very underappreciated solution to certain types of network problems. Most importantly, it can be an alternative to structural breakups. Structural breakups are typically harmful if we're not breaking up recently acquired assets. And interoperability can perform a useful alternative for that. We've actually gotten a fair number of interoperability decrees in antitrust history. Mark mentioned the AT&T decision in the early 80s, all the way back in 1912 in the Terminal Railroad decision. The court mandated joint access and operation of a railroad bridge and loading terminal. The very famous AP case in the mid-40s required shared access to a wire service that the press used. These were pre-digital, but they're very important predecessor cases. In general today, we think network industries that do not have dominant firms seek out interoperability voluntarily. A good example of that is email. Email has been fully interoperable almost since its inception. So if you own an Outlook account and I own a Gmail account, you can send messages to me and vice versa. And other than the little hashtag at the top, you don't really know what carrier I'm using for my email. It can be judicially mandated, as it was in the AT&T consent decree in the early 80s. And then it can be mandated by legislation, as it was in the 1996 Telecommunications Act. So, there's lots of ways of getting there. The real problem is deciding when we need it. And Mark, I think, puts his finger on a pretty important thing, and that is too much interoperability can tend to homogenize the entire industry so that everybody just becomes a licensee of someone else and is delivering the same product. So you really do have to figure out where freestanding competitive operation is advisable, because that's the way we get true competition, and where shared access through interoperability rules is necessary. So, here, as in always, the devil is in the details.
Thank you, Herbert. Diana or Summit, do you guys want to sort of take on the interoperability question?
Sure, if you don't mind. I mean, yeah, I think the devil is in the detail. At the same time, I think when you start looking at the details, things are maybe not as complicated in implementing some of these solutions. So, when Facebook grew, it grew by accessing people's email contact list, right? It would go into people's emails, see everyone else you were emailing, and then contact them, say, hey, join Facebook. So some of I think a solution like that, limited interoperability. I think no one's, I agree with the others here. It's not a good idea to propose full interoperability where there's no difference, right? You need limited operability so that each platform retains incentives to innovate and develop its own services. So for example, for Facebook, it could mean when you move to another service, you have access to your contact list so that if your friends move to the other service, you could get in touch with them and connect with them. It could also allow for cross-posting. But that doesn't mean everything about the two services need to interoperate. There can still be special things about Facebook and special things about TikTok or whatever other platform you move to. I'll stop there.
Thanks. And Diana, do you want to take on the portability and interoperability question?
Sure. So the whole concept of interoperability is, as Herb points out, really fundamental to vertically integrated industries going back, to the beginning of time. Railroads, electricity, pipelines. I'm a former federal energy regulator and worked on an open access rule at the FERC for electricity markets, wholesale markets for several years. And there were a lot of very technical questions to be answered. And this sort of gets to the bigger issue here around whether strengthening and creating expanded authorities under the antitrust laws to go to address or rein in the market power of the digital platforms is going to be enough. And, I'm not sure it will be. In fact, Michael Bennett has introduced a bill recently that would essentially set up a Digital Markets Act for the United States and form a commission, a 5-person regulatory commission to oversee the digital sector. And of course, interoperability and incentives to discriminate on platforms is really central to the competitive problem here. The question is whether a sector regulator that possesses the engineering and the technical expertise to deal with a very complicated business model, the digital business model, is going to be the more effective policy tool working alongside very strong antitrust enforcement in the sector. And I think there's a lot to be said for that argument. Summit has pointed out quite accurately that a lot of the digital ecosystems are unique. We see a lot of market failures, network effects, for example, or the bandwagon effects. We see what we call data externalities. Little data goes a long way. We see big economies of scale and scope in cloud infrastructure. These are very technical engineering economic systems, and a dedicated sector regulator with the technical expertise to develop an access regime with non-discrimination at its core and interoperability within the core of that is very much worth considering as a complementary policy tool to stronger legislation to enforce the antitrust laws in the digital tech sector.
If I could add to what Summit and Diana were saying, I disagree. We need a sector regulator, but let me go back to the interoperability issue. And Summit is exactly right that the way that companies would interoperate if they want to is very specific to the technical issues, the business issues, and what they think the future is. So it's really hard to have a single set of rules and try to have everybody live by them. In fact, once we went through a lot of legal processes, defining terms, et cetera, the markets have moved on a long time ago, which has happened before in antitrust cases. We actually had this in telecommunications, as stodgy and staid as telecommunications was at one time. When we required the interoperability, it took us 2 or 3 years. We finally got it done. But what happened was that interoperability was for telephone systems, and the market moved on to wireline phone systems. The market moved on to wireless. It moved on to broadband internet. And those interoperability issues just didn't matter anymore. In fact, it actually held some of the competitors back. We had some legal fights when the incumbent telephone companies wanted to upgrade to fiber optics. Their competitors said, wait a minute, we interacted with you, we interoperated with you for copper. You've got to keep the copper in place. We can't rebuild our whole networks just because you want to modernize. We don't want to step into that and hold things back in the digital space by repeating some of those mistakes. It really needs to be something that companies work out. And if somebody is biasing and has power and control and harms consumers in the process, then we should take our current laws and prosecute.
Okay, thank you. I'm going to go to our first audience question, which is not, or I'm going to combine actually two audience questions. They're about the American Innovation and Online Choice Act, talking about some of the exceptions to online platforms, at least as I understand the questions. One regarding a carve out around payments, where I think the bill just takes the word payment out of the online platform definition. So why is that carve out there? And another one about enterprise software, if I'm reading this question correctly. So let's talk about just generally like how online platforms are defined and like whether payment should be part of the definition or not, and same with enterprise software, or whether the question sort of misinterpret what's in the bill. Anyone want to take the carve out? Okay, Summit, I'll let you go.
I think I would just say it's not a carve out, because I think payment systems like credit cards, etc., and banking systems were never meant to be covered by the bill. And if you read the previous version, I would have read it to say they're not covered. For example, very difficult to argue how when you have a choice of 10 banks, any one bank is a critical trading partner. Similarly, when you have so many different credit card issuers, the same applies. But of course, there were complaints that it may be covered in some reading. And so I think the latest version made it crystal clear that this only applies to the largest online platforms, so the Google, Amazon, Facebook, Apple, and Microsoft, and not everything else. So I would disagree. It's not a cover. It was never meant to be covered and just been clarified.
Okay. Anyone else? Go ahead, Diane.
Yeah, and let's not forget Senate Bill 2710, which is Senator Blumenthal's bill on the open apps market, right? Which directly addresses the sale of applications, apps through what is essentially a duopoly, right? Google Play and the Apple App Store. And that goes directly to the issue of payment systems and the ability of apps developers to process payments outside of the App Store, the in-app purchase system. So I think we're getting now different pieces of legislation that address these issues in the digital tech sector that ultimately should be working in complementary ways to each other, right? As opposed to creating overlaps or conflicts or anything like that. We haven't seen that thus far, so that's a credit to how these bills have been thought out and how they work individually, but also work as a collective.
This illustrates why putting these kinds of things in the legislation can be very problematic, because we have to say, well, the payments is part of a platform, but sometimes it is not, or sometimes it is. And these are very dynamic systems. If you look at how technology is evolving, it's always changing. What's the functionality in the platform? What is it going to do? And what is the nature of the products and what is not? To try and define the market in legislation becomes very problematic, because customers will want to move on. Industries will move on. The question is, will they move on here or in some other country? And if we try to prescribe markets and what companies can and can't do very precisely in legislation, we're going to ultimately damage what we can do in the US.
Can I just say that I have to correct a little point there. I mean, the bills we're discussing here, S2992 and the Open Up Markets Act, there are no business line restrictions in any of these bills. So these companies are free to do other businesses. In fact, the smaller businesses that these firms undertake, for example, if Apple wants to, start a search service, general search service, it can do it. There are no restrictions. So I just want to clarify that.
Yeah, it defines what the business is, not the company, but what this particular functionality, this particular business is. It is this kind of a thing, and it is, we call it a platform. 5 years from now, if that's irrelevant, well, tough. The law's still in place.
Okay, I just want to let the audience know, so we're at time, but the panelists have all agreed to talk for another 10, 15 minutes. So if you want to stay on, please stay on. We're going to ask now questions about ways to either improve the legislation or reasons why you guys think it's perfect as is, or is just irreparable, depending on your perspective. So let's start with the S2992 bill. So any suggestions on ways to either improve it, or you think it's great, or you think that it's just unsalvageable? So I'll start with, I guess, Summit, I'll start with you. About ways to either improve the bill, or the case for keeping it as is, or just doing away with it.
I think the bill is in good shape. We should, it's iteration of a bill that was introduced in 2020 in the House, right? It's gone through 2 years of changes, and I think the bill is in a good place. Let me just make a different point, which is this: that the bill has a 1-year implementation phase where the FTC and DOJ can come out with guidelines to say exactly how this is going to be implemented. I think that will be a crucial phase for both the FTC and DOJ to come out with detailed guidelines to say what they expect of these companies, and for these companies to come up with innovative solutions to make sure that the conduct is in line with the bill, assuming it becomes law, of course. So I think it's the implementation phase where a lot of work will need to be done, but that is how it should be. The Sherman Act is only a few lines. We have vertical and horizontal merger guidelines, but do a lot of the heavy lifting in that case, and I think that can be done here as well.
Herbert, do you want to take that question next?
Yeah, I think the bill is going to be a big failure unless it makes two important changes. One is there has to be a market power requirement with respect to the particular product or service for which self-preferencing, unlawful self-preferencing or discrimination is being alleged. So if it's a claim brought by a seller of clothing on Amazon or something like that, you'd have to look at the market, and there would have to be a serious market power requirement. Otherwise, the idea of anti-competitive self-preferencing pretty much falls apart. And then secondly, it needs to have a more clearly articulated competitive harm requirement. Just simply saying materially lessen competition, kind of throwing it to the courts and say, okay, what do you think we should be meaning by this? I think there has to be a reasonable likelihood, a reasonable showing that a practice is going to be lead to reduced output, higher prices, less innovation in a market, and not simply a tort-like injury that accrues to one particular complainant.
Okay, Mark or Diana, do you want to take that question? Otherwise, we'll move to a portability interoperability question.
Yeah, I'm happy to chime in there. I guess I would revert to my earlier comments. The bill obviously has the right idea to approach what is a pretty serious market power problem from vertically integrated digital business ecosystems. We've talked all about that. It basically takes on Sherman Act 2 types of authorities. As Herb can attest, the standards for bringing monopolization cases in the United States are extremely high. And this bill is essentially a workaround to be able to get to those forms of conduct. But I would again reiterate, this will play out in the courts. So how courts deal with affirmative defenses for otherwise anti-competitive conduct around privacy and security is an open question. And whether algorithmic preference shaping, which would be very difficult to detect because it's all within the algorithms that are developed and enriched and enhanced using machine learning and AI. How the courts deal with that, I think, is also key. Now, whether that comes out through agency guidance, as Summit pointed out, right? The agencies do have the authority to issue guidelines, or whether that comes out in the case law is unclear. But those are really things to watch for here if this bill passes into law.
Thanks, Anna. And Mark, do you have anything you want to add?
Yeah, the AEIA doesn't take a position on particular bills. We can say this is good, this is bad, but I won't say, yeah, you should pass this or you should change it this way. What I would hope that Congress would do, if it's going to do something, is confirm that markets are about the customers. It's not about the businesses, it's about the customers. And that's our standard for how we think about what antitrust should be trying to accomplish. And understand that we are in a very dynamic global market. And there's a lot of competition, not just between companies, but sometimes we have governments competing against companies. And that becomes a different way of understanding the dynamics that are going on. We want to zero in on, is there something that's protecting a company from competition? If there is, let's go after that particular issue. That's what I would encourage economists, lawyers, engineers, et cetera, at the Federal Trade Commission, Department of Justice to zero in on. And then also make sure that we don't let politics creep into the antitrust and the regulation there. This is something that it's a constant fight. I have a piece come out on it today where I'm worried about it again. We want to make sure that this is about the substance of issues and not about who's liked and who's disliked at any particular moment.
Thanks. So I'm going to have two more questions. One's going to be about portability interoperability bill. What would you do in that? But we'll get that in a second. And then the last question is going to be giving you 30 seconds to a minute to summarize your thoughts to a policymaker who can only watch a quick clip. So let's start with the portability interoperability question. So the Access Act, as I mentioned earlier, is a bill that's been reintroduced around portability interoperability standards. I don't know if there's other bills out there, there probably are. If you were to tell Congress or advise them on a portability interoperability bill, what would you say to them about ways to either improve an existing bill or a different approach to portability interoperability? And I will start with you this time, Mark, if that works for you.
Yeah, I would tend to stay out of it. But by time you pass legislation, and by time somebody tries to turn it into laws, rules, whatever it might be, the market's moved on. And so you really need something that's a lot more dynamic and focused on the real problems that are occurring, and rather than how are we going to engineer how a business might operate.
That works. And someone, I think your hand was up, so I'll let you go next.
That's right. There's a fly. But yeah,
okay.
I would say, hey, so I would first challenge the assumption that the market has moved on, because these same firms have been dominant for the past 10 years in many online activities. So I don't think that is true. Given that, I think it is correct to set some portability and interoperability rules, but I agree it should be limited to certain aspects which are key for a new company to enter the market and start. For example, having access to your contact list and the ability to port your contacts is one example. And that's a general point. And the bill, if we have one, Access Act, I think the House version that we had last year had a lot of stuff about setting detailed rules for each different covered platform. Because I agree, these are different businesses. So you need detailed rules for each of them separately. So I'll stop there.
Thanks, Summit. I'll let you go next, Herbert. If
I think we should dump that bill. The equitable powers of the federal courts acting under the Sherman Act are already incredibly broad. The two interoperability decrees I quoted to you a while ago from Terminal Railroad and Associated Press, those are both Sherman Act decrees. The government, the federal courts already have the authority to order those kinds of remedies. AT&T was a consent decree, but there was no question that the court would have had the authority to make those orders if it needed to. And orders in antitrust cases, remedies in antitrust cases are incredibly firm and act specific. And I think we don't want to start messing around in legislation that classifies them because the courts have, it's a hard job. I don't want to say it's an easy job, but the idea of coming up with an adequate remedy in a monopolization, cartel, joint venture case, merger case, we have a wealth, a very, very large quiver of arrows that already give us all of the weapons that we need in this area, including mandated interoperability or data portability, if the government can make a showing that those things would solve the competitive problem at issue.
Great. And Diana, do you have anything you want to say on the portability and interoperability issue?
Sure. So I think we have durable monopolies in the digital tech sector. I would wholeheartedly agree with Sumit on that. These are not going away. Part of it is, as I said earlier, the result of the business model, a growth by acquisition business model that has where antitrust has failed. There's been one challenged merger case in the digital tech sector in the last 20 years, and that was Google ITA. A very weak record of merger control. So these are fast-growing systems. They grow through acquisition. They are now durable monopolies. We can't forget about the up-and-coming players. But if we have decided as a public policy matter, this is a public policy problem, that we need to address issues of competition in the digital tech sector, I would really strongly put a vote in for a dedicated sector regulator with the technical expertise to do that. I don't think antitrust as a device, a tool of competition policy, or the courts are in a very good position to be thinking through what are very technical engineering issues that would be best left to an expert sector regulator. Unfortunately, there is no support in the United States for sector regulation. The GOP is well known. You can't say regulation to the GOP. They run in the other direction. It's viewed as an invasive, unnecessary intervention in the market. And I think a lot of people are thinking about regulation in digital tech as sort of public utility regulation, price, profit, entry. That's not what's at issue here. This is access regulation, including things like interoperability and data portability. And the way the conversation has unfolded in the United States around competition in big tech is very odd, very odd. It's very different than what we've seen in Europe, where it's been absolutely a dual track. Let's look at potential sector regulation. Let's look at stronger competition enforcement. We're not having that debate in the United States. And it's unfortunate that it's a very narrowly focused debate.
Great. Thanks, Diana. Okay, so we're going to be super quick with the last section. Just 30 seconds, what you would say to policymakers if you just had 30 seconds to speak with them on this competition policy and big tech debate. And I'm going to start with you, Mark.
I would focus on making sure that people have the freedom to try things and fail. I would not use Europe or someone else as a model. Most innovations happened here. I think we can keep it that way with liberal markets.
Thanks, Mark. Sumit, your 30-second pitch to policymakers.
Support the American Innovation Choice Online Act and the Open Up Markets Act. These are well thought out policy proposals. They're also popular. Consumers have an intuitive understanding. They're no longer in control. They can't switch to other services. And we did a survey recently which said 3 out of 4 Americans worry about the power wielded by today's biggest tech firms, and 60% would support government action to mitigate harmful conduct. So please support these bills. Thank you.
Thanks, Sumit. Herbert, your 30-second pitch to policymakers.
I think you have to start with the premise that this is one of the fastest growing parts of the economy. Our potential to screw it up is a whole lot bigger than our potential to make it better. If we are going to intervene, it needs to be in cases of proven market power and then proven remedies that are likely to improve competition.
Thanks, Herbert. And Dan, I'll let you wrap it up with your 30-second pitch.
Sure. My messaging, AAI's messaging is that in digital tech and in other sectors that are equally troubled with competitive problems like food and agriculture and healthcare and transportation, that Congress really think about coherent competition policy, which consists of multiple tools: stronger antitrust enforcement, privacy law, intellectual property law, labor law. It has to be a toolkit approach.
Thank you, Diana. So with that, I'm going to wrap up this panel and event. I just want to thank everyone on the panel for joining us. This was a fascinating conversation. You gave us a lot to think about. I also want to thank many of the people who made this event possible, including Danielle Draper, Elizabeth Wall, Sabine Neshka, and our vendors. These events, you see us on screen, but there's a lot of people behind the scenes who help make these things possible. Finally, I want to thank our audience for watching. We appreciate your viewership, and please join us next time when we host our next event. Thank you. Thank you all. And with that, I will conclude this event.